Please be seated. The court is ready to hear argument in our second case, 22-889, Oscar Renda Contracting versus Bruce.
May it please the court, Mr. Anderson will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. 41003D of the Civil Practice and Remedies Code mandates that punitive damages may only be awarded on a unanimous jury findings on underlying liability, gross negligence, and the amount of punitive damages. Obtaining those affirmative findings is clearly the plaintiff's burden, just as it is the plaintiff's burden to satisfy the requisite elements.
Was there an instruction that, with regard to exemplary damages, that it had to be unanimous?
Yes, there were instructions on question 7, which was the first. It was the gross negligence question.
No, I think it was 8, was the one about what sum of money should be awarded for exemplary.
There was not a specific question as to 8, other than that the jury was instructed that in order to answer question 8, they first had to answer question 7.
So was there an objection to that?
Neither side made an objection to that. That was overruled. So
does that waive it then, because you have to object to any error in the jury charge?
First, I don't think it was Oscar Renda's burden to object to that, because that finding is necessitated by 41003, and it is part and parcel of the plaintiff's burden. And the respondent homeowners were not only the plaintiffs in this case, they were also the appellants. They are also the party that challenged the judgment. And in addition to that, they were the party that stood to benefit by having those positive findings. Now, that's a bit circular, but that's the fact. They were the party that needed that. If the charge is defective, that's going to prevent them from getting the verdict that they want.
Go ahead.
Yes, ma'am.
Okay. Did the charge itself, it seemed to follow the Texas pattern jury charges, except about maybe 2/3 of the way down, the sentence that instructs the jury that they must be unanimous on the finding of punitive damages is deleted. Is there any understanding of how that happened?
I think you're referring to the absence in the instruction on before question 8.
Right, and that it otherwise tracks the pattern jury charge exactly. It just removed that.
I was not the trial counsel on the case, so I'm not in tune with specifically how that happened, and I don't think the record makes that super clear either.
So I think the Bruce's rely on the Osterberg case that says that if there's an unobjected to error in the charge, the sufficiency of the evidence should be evaluated according to the charge as given. What is your response to their argument that that law applies here?
First of all, I think that the party that is going to suffer the most harm if it's applied as given is the respondents. Because if you look at the charge, and Osterberg v. Peck and several other cases say that you look at the common sense wording of the charge and then in the context of the case. But the common sense wording of this verdict is that the jury certified that their verdict was not unanimous, and that only 10 of 12 had answered yes to every question. And so that's the verdict that the respondent homeowners have to live with. And the second part of your question, one distinction in Osterberg and all these other cases that say that you have to live with the judge, or the verdict and the charge is the way they are. Rarely in those cases does it align so perfectly, where one side has the burden of proof around every turn. In this case, the homeowners, the plaintiffs, They're also the appellants, and they're also the ones challenging the verdict, or rather the judgment. And the verdict that they needed is the charge that they failed to object to. They failed to secure the questions they needed to get the answers they wanted.
So your point is that the trial court on this question ruled for you, and so you have the shield of the judgment and any reasonable basis for affirming it, as opposed to the case in which you made the arguments that everybody's making right now to the trial judge, and the trial judge ruled against you.
Yes, I think that's a fair summary of our position. But in addition to having the charge, the judgment, we also have the only definitive answer as to unanimity, and that is that the jury answered yes, only 10 of 12 on all questions.
So you're happy to take what the charge says because it says only 10 answered yes to that, or at least it doesn't conclusively show that 12 answered yes.
There's nothing definitive to indicate that any of the jury's answers were unanimous, other than the simple fact
Well, what about question 7? It says only answer the gross negligence question if you're unanimous. Isn't that an indication they were unanimous on that question?
It's the United Scaffolding versus Levine case that says that you assume that the jury followed directions unless the record demonstrates otherwise. And that's exactly what we have here.
Well,
Why?
but
Go ahead.
isn't the record unclear about that? Because we really don't know what happened in terms of, right?
There's nothing other than just speculation that the jury answered any of those questions in affirmatively, other than the fact that they answered question 7.
Well, why isn't that good enough? Because it doesn't seem contradictory to the certificate, which says 10 of us have agreed to each and every answer. So it could be true that 10 agreed to each and every answer and 12 agreed to the answer on, both of those things can be true, that 10 agreed to all the answers and that 12 agreed to the answer on whether there was gross negligence, right? Those don't contradict each other.
Well, you're right, they don't directly correct or contradict one another, but there's no definitive showing. And it's one assumption that follows a second assumption in order to reach that conclusion.
But don't we have to reconcile the verdict in favor of the jury's findings?
I don't think that you do.
I thought your point was more that we can't do that on question 8, which is the amount of exemplary damages, because there's nothing to indicate that was unanimous because the conditioning instruction was missing, saying only answer if you're unanimous.
Right. Maybe I misunderstood the import of your question. Do you have a follow-up?
I think I understand your argument. You can go ahead.
Okay. So, that's it in a nutshell. The burden on every turn here was on the homeowners. They didn't satisfy that burden. The only definitive point that can be determined without going into assumptions is that the verdict was not unanimous. And on top of that, I think that the certification holds special significance, particularly when the mere fact that they took the act of answering question 7, that's not a finding. It's incidental to
What case says that's not a finding?
Well, I think that's just common logic.
It says only answer if you're unanimous, and they answer. You think that's not a finding that they were unanimous?
I don't think it's anything as high of the degree as their answer on the certification, which is what...
The certification addresses this. Rule 226A says very clearly how you're supposed to do this, and it just doesn't seem to have been followed.
Well, and that's because of the defects in the charge, which are certainly not attributable to Oscar Renda. Oscar Renda didn't have the burden on any of these matters. And I think by extension, the court's ruling in a similar case, Zaria versus Aitko, that was a companion statute, 41008. And I understand that it was a different issue. It had to do with whether the caps on punitive damages constituted an affirmative defense. Nonetheless, it's instructive because the court specifically found, and the language is very interesting, it's a fundamental principle that 4100A does not impose a burden of proof on the defendant. It certainly doesn't in 41003 either, and particularly not when the judgment is in Renda's favor, and Renda's not the appellant. And so when we come down to preserving error, that's got to be fairly on the plaintiff and the appellant and the party challenging the judgment. And the language of these cases say that again and again. On top of that,
do our omitted element cases bear on this at all? Because we've said, if a plaintiff submits 3 out of 4 elements of a cause of action and gets a finding on that, and the defendant doesn't object, then the missing element is deemed found by the jury. Is a conditioning instruction like that, not like that, in terms of how many votes you need? Are there any cases that shed any light on that?
I don't have an answer to that, Your Honor, and perhaps I could answer that in a letter brief if that would help the court.
If you find some helpful cases, but if not, it's just trying to figure
It's
out
an
how that
interesting
fits with
question.
some of our other charge precedent.
Yes, and of course, that's not an issue that came up in the briefing, and it's not something that I felt that I was at liberty to bring up. I would like to be able to answer your question, but unfortunately...
If you have something helpful, you're welcome to submit a letter, but if you don't find anything helpful, don't feel that you need to.
Thank you.
As to questions 1 and 7, I'm inclined to think that it is established that those were answered unanimously. We decided last year in Rudolph Automotive that jurors are presumed to follow instructions, and the burden on someone who's going to show otherwise is to show something in the record that they didn't. And I'm not sure that the answer that you have given, that they've certified that 10 out of 12 signed the entire verdict, dislodges that presumption. So let's just assume for the moment that I'm implacably going to assume that 1 and 7 were unanimous. What is your best answer as to why 8 was not?
There's nothing in the record that indicates that it was. That the instruction that the plaintiff needed, the plaintiffs, to get that response was lacking. And that's...
That distinguishes 1 and 7 pretty clearly, right? Question 8 did not have that instruction, so the jury could go ahead and answer it, not be unanimous. Nobody asked them to be unanimous, and they went ahead and signed the certification as to 10 and 12, meaning that, yeah, we all answered 1 and 7, maybe some of the others, but not all of them. And that's, the colloquy you've been having, I think it's possibly as simple as that. Is that your argument, or am I making up an argument for you?
I think that to the extent that it's Renda's burden to show in the record that it's not unanimous, despite the fact that there's not really any definitive evidence of it, the only other thing that I could point to would be the polling of the jury. I understand that that's repetitive of the information that we already have through the verdict, but it is cumulative, and that's got to be at least some value. And again, at the end of the day, another point is that 324B, Rule 324B, it allows an appellee to preserve error through a cross point. And cross points, of course, are determined liberally. They don't have to be labeled cross points. And then it goes on further to say that anything that would vitiate the verdict is effectively preserved in the same way under Rule 324. And so I feel that Renda has preserved its arguments.
Would you just clarify for me, did your client's trial counsel object to questions 7 and or 8 on any ground at all?
Trial counsel objected to the instructions as a whole based on the argument that there was insufficient evidence for those matters to be submitted.
But that was the only basis on which they objected to 7 and 8, was insufficient evidence?
There were no other objections by any party.
Could you spend a minute talking about, you're not challenging here the jury's finding of negligence, but you are saying there is no evidence in the record to support the finding of gross negligence. And those 2 points seem at least to be a little in tension, right? You're not challenging negligence, but what is your best argument about why, conceding that there was some evidence of negligence, why that can't rise to the level of gross negligence? Is it more to do with the subjective component or the objective component?
The arguments that were raised in Renda's briefing, which, in fairness, I was not the author of those briefs, so I'm not quite as familiar with all those factual arguments, but I will acknowledge that that your argument has some appeal. So,
but you don't concede. You don't concede there's evidence to support gross
I'm not in a position to concede that, but the factual and legal sufficiency arguments, those are not our most important arguments.
Any other questions? Thank you, Mr. Anderson.
Thank you.
We'll hear from the respondents.
May it please the court, Mr. Gray will present argument for respondents.
Mr. Gray, we're getting a little ringing in here. You might pull that microphone down just a bit.
Absolutely.
Yeah, great.
Chief Justice, and may it please the court. My name is Garrett Gray on behalf of the respondents. The judgment of the 8th Court of Appeals should be affirmed for 2 independent reasons. First, Renda Contracting has not and cannot show the jury was not unanimous in reaching its gross negligence finding, giving the trial court no basis to set aside the jury's verdict. And second, Renda Contracting has failed to preserve any error or any alleged conflict in the jury's findings. Justice Busby, you asked about cases from this court dealing with charge error and preserving error that might be instructive. And I think there are a few that this court could look to, starting with Burbidge versus Burbidge from 2014 from this court. You have Ramos versus Frito-Lay Incorporated, as well as American National Petroleum Company versus Transcontinental Gas Line Corporation. And in all 3 of those cases, there is either an omitted instruction or an omitted question of damages on a theory or an element. And this court reasoned under Rule 279 that when a theory is submitted to the jury and there is an instruction or an element missing, the burden is on the defendant to object to that error in the charge in order to preserve
that gets to the preservation issue, which I thought was your second point. I'm interested in hearing first, your first point is, on what basis could we ever assume or treat as if that the jury was unanimous on question number 8?
So as to question number 8, admittedly there was a defect there. It was missing the unanimity instruction as to the amount of exemplary damages. But because that was not preserved and because of what this court has said in case.
So as to your first point is, as to question number 1 and 7, we can just look at the charge and can assume, in fact must assume, that the jury followed the instruction. They didn't answer, because they answered 7, they must have answered 1 unanimously. That's what the instruction said. And then they only answered 7 if they were unanimous, and so I get you there. But you do agree that with regard to question 8, the amount of exemplary damages, there's no basis on which we can assume that was a unanimous decision.
Correct. There's not an entire basis to assume that. Now, question 8 did tell the jury only answer this question if you answered yes to question 7. Right. So in order to get there, they had to be unanimous.
Well, no, they had to be unanimous on 7.
Correct.
But there's no basis to think that they were unanimous on 8.
Question 8 is lacking the unanimity instruction, yes.
So then we get to your second point, which is, however, they didn't preserve that objection.
That's correct. And additionally, in Renda Contracting's briefing to the Court of Appeals, they don't challenge question 8 at all. And additionally, they refer to any error as to question 8 as harmless.
Well, it sounds like they're happy to accept question 8 as it was rendered, because it's a 10-2 verdict on the amount of exemplary damages. And the statute says you have to be unanimous both as to whether you can get exemplary damages and as to the amount of exemplary damages, right?
Yes, Justice.
Okay, so why can't we just, I guess, it was defective because it doesn't get you what you want, but in itself, there's nothing wrong with the question, right? I mean, it's fine as it is. It just doesn't support the relief that you want, I think, is their position. So why is that wrong?
It's wrong because omitting the unanimity instruction is essentially akin to omitting an element, for instance, in which there was no objection ever to omitting that instruction or that requirement, and this court can essentially, because it was never challenged, deem it as.
Deem it. But then we would look, if we had a deemed finding case like that where an element's omitted, then we go and look at whether there's any evidence to support the deemed finding. And so what would you point us to as evidence that the jury actually answered question 8 unanimously?
As to evidence that the jury answered question 8 unanimously, I think you would look first to the instruction on question 8 to only answer question 8 if you had answered question 7 yes, which means that the jury up to that point was unanimous. But admittedly, that there's not much after that to do.
Yeah, I mean, if here, I guess the way to think of it, if there was a question 9 that says, "Is the sky blue?" Jury says yes. Do they have some, and then the trial court says, I'm going to award $1 billion because the jury said the sky is blue. Well, that's no legal basis to award anything. Did they have some duty to object to the question? I mean, to me, that's what their argument is here, is look, you can ask all day long if 10 of you think that $75,000 per plaintiff is the right amount of exemplary damages. You can ask that all day long if what 10 jurors think. We don't care. Go ahead, do it. We're not going to object because whatever answer you get doesn't give you an amount of punitive damages. That's their argument. Why is that wrong?
It's wrong when looking at, for instance, Osterberg, which says the charge submitted to the jury is what controls on appellate review. And so this charge here.
The sky blue. That's the charge submitted. I mean, okay, you can submit it, but I don't have to object to it. Get all the irrelevant answers you want.
In connection with this idea that we have to look at the charge as submitted, does it matter that the Civil Practice and Remedies Code, which has a whole section devoted to particular standards of proof and requirements to get punitive damages, which are to punish someone as opposed to compensating someone. In the Civil Practice and Remedies Code, it says that each of the elements, including damages, must be unanimously found. And it says, this burden of proof may not be shifted to the defendant. What do we do with that? Is this idea that it could be deemed against the defendant really then shift the burden to the defendant?
No, I don't think that's a shifting of the burden, because in any context, I think this court has always found that when a theory of liability is submitted to the jury and there's a defect or an omission, there's always the burden to object and preserve error. And if that fails to happen, the charge submitted to the jury is what controls on review. And so I don't think there's any shifting of the burden here. The burden absolutely is on the plaintiffs, or here the homeowners, to procure the finding.
And then in connection with this idea of the burden for objecting, the cases that you cite, and usually the way the cases come to us is that the defendant has lost that issue in the trial court. So in order to preserve error, the defendant had to let the trial court know, hey, wait a minute, the verdict's not unanimous. In this case, though, the defendant won this point in the trial court. The trial judge agreed this is not a unanimous finding on the amount of damages to punish the defendants, and didn't enter judgment. So how do preservation principles come into play? They don't have an error in the trial court's judgment that they seek to preserve. They like the trial court's judgment with respect to punitive damages, at least.
Preservation of error comes into play with how we got to this judgment in the first place, which was after the jury was already discharged and after the homeowners had filed their motion for entry of judgment. For the first time, Renda Contracting wanted to rely on what they assert as a conflict in the jury's findings. But looking at this court's plurality opinion and Menchaca, as well as in Los Compadres Pescadores and in Ray Rudolph, if you are going to rely on an alleged conflict in the jury's findings, that needs to be raised before the jury's discharged. So I think
But in their view, there's no conflict at all because we have the jury verdict form and a poll of the jury, and in both instances, the jury said they were not unanimous.
Correct. In both instances, the jury said they were not unanimous, but that does not disprove that they failed to answer any question unanimously. And that's something that the Court of Appeals detailed in their analysis and the majority opinion, and something I think Renda Contracting continues to sidestep. That Rule 226A contemplates this very scenario.
Exactly. Rule 226A contemplates this scenario, and so does the pattern jury charge. And they both lay it out. This is exactly how this should all work to be sure that the jury's answering unanimously when they need to, and not when they don't need to be. And you check these boxes, and it all becomes very clear exactly what the jury has done. So why wasn't that followed in this case? It's to avoid this very argument that we're having today. That's why the Rules Committee and the Pattern Jury Charge Committee spent the time to do that.
Yes, that's correct. And unfortunately, the record doesn't reflect why exactly it was omitted in this case, why the error took place. I can't point to the fact that the homeowner's first amended charge submitted to the trial court, which can be found on the record at Volume 10 of the court reporter's record at 6645, did include a unanimity instruction as to question 8. And unfortunately, the record's not clear as to why that did not make it to the jury. But this is not an example, for instance, of anyone trying to pull a fast one on the other side. I think it's a reflection that in trial, in the heat of battle, there's going to be errors at times. This court has talked about before in its cases that the trial court doesn't always have time to scour every single word or every single sentence. And so in this situation, Renda Contracting has been on notice for quite some time that the plaintiffs were seeking exemplary damages through gross negligence. I think there's a line from the United Scaffolding dissent that's very apt here. That the defendants have been on notice since about 1940 of what Rule 79 requires when there is a defective charge submitted, and that's to object.
So if the instructions on question 8 had said, you may choose an amount of punitive damages if 10 of 12 of you agree, and so it's facially out of compliance with the statute, but and they don't say anything. The defense does not object to that for whatever reason, and then the answer is yes. Are you saying you get to recover punitive damages despite the facial noncompliance of the verdict with the statute because they didn't object to the charge?
I think that's a much tougher case, but I still think...
Why would that be a tougher case on the waiver question?
I think the waiver analysis would stay the same in that situation, that they failed to object, and so the charge submitted to the jury would be what controls in that situation.
Don't we functionally have the charge that Justice Blacklock posits here, because the initial instructions say, unless otherwise instructed, the answers to the questions must be based on the decision of at least 10 of the 12 jurors. So shouldn't we assume that the jury followed that as to question 8?
This court could assume that based on that.
We have to, right?
Correct. There is a presumption that juries follow the instructions they're given. That's something this court has repeatedly emphasized.
And so then when the judge takes that verdict and is forming it into a judgment, doesn't the judge then have to follow the law? If the jury, if 10 of them said this, no question about that, but the law says that in order to have a punitive damages award in a judgment, I have to have unanimity, and I don't have that.
I think in that situation, the trial judge should still be bound by the charge that's submitted to the jury, particularly when there's never any objection to it.
I mean, there's no question that the jury would have given that answer. They would have gone ahead and instead of ensuring their unanimous agreement to the amount, they put the amount in there. And maybe said, yeah, there are 10 of us that found this, but nonetheless, at that point, we now know, what the jury says, but we also know what the law says. So, I mean, instructing the jury doesn't change the law, does it, in a case like that?
Not necessarily, no. Instructing the jury doesn't change the law, but in order for the trial court to set aside jury findings, you need...
Well, it's not setting it aside. It's just saying it doesn't lead to a judgment. It's not setting it aside. It just hasn't reached the level that the law requires for it to be converted from a verdict into a judgment.
That's correct. I still think in that situation, it's incumbent on the other party to raise that issue to the trial court and give the trial court a basis to do so.
Well, let me ask you this. The discussion you had with Justice Bland about the statutory language that says you can't shift the burden of proof. What if the instruction in number 8 had said, you must all be unanimous and you must award punitive damages unless Oscar Renda proves that punitive damages would be improper, and there's no objection from Oscar Renda? What result then?
In that situation, given their lack of objection to the charge, I still think the charge there would control. Even though the statute provides there's no shifting of the burden, there's a conscious waiver on Oscar Renda's part. And I think it's important to step back and look at what you can waive in court. For instance, you can waive your right to a 12-person jury trial under the Texas Constitution. There are
Well, does the Constitution require a 12-person? I mean, can you waive it if the Constitution required it? The Constitution said such and such a case may only lead to a judgment upon a verdict of a jury of 12. Could they waive that, do you think?
Yes, I think they could. And in fact, the Texas Constitution does provide that in a district court you have a 12-person jury. And there have been numerous cases in the Court of Appeals in which, in that situation, it has been waived. For example, Dixon versus J. Weingarten out of the 14th Court of Appeals, as well as Audia versus Hanold out of the Dallas Court of Appeals in 2010. In both those cases, you had a waiver of your right to a 12-person jury.
You have a right to it, but what if it isn't your right? What if the Constitution says, it doesn't say this, we think that a judgment can only follow if there is a jury? Not that you have the right to demand it and that right must be respected. In that instance, it stops being something that's just about the parties. And my question to you is, why should we not read the statute, particularly in the punitive damages context, in which, as Justice Bland pointed out, those are not compensation. Those are not personal, really, to the plaintiff. They're a way that the law allows for a kind of civil punishment that's the interests of society. And so if the law says this is the requirement to do that, our courts will not enter into this particular thicket unless this happens, how is that something that is really even waivable?
I think it's waivable because a judgment here with exemplary damages doesn't cut against the interest of justice, in that the other side has had notice of this claim, and when you have notice of the claims against you, you have the burden to object if there's a flaw there. And so in this case, both sides understood what was at stake, that there was potential exemplary damages, and so any error or failure to object on the part of Oscar Renda is their own doing, and not something that goes against the great interest of justice that perhaps something mandated in the Constitution would.
There seems to be two aspects of waiver that you're arguing for. One is the Osterberg line of cases that say that we measure the sufficiency of the evidence under the charge as submitted. But here, we're not measuring the evidence in the case. Is there a case that applies that Osterberg line to the deemed element side of things?
I think applying the Osterberg side to the deemed element, I think even in some of the cases I previously mentioned, such as Burbage versus Burbage, Ramos versus Frito-Lay, even though there were errors in the charge, that was still what controlled any sort of legal sufficiency review in that case.
And then the other kind of waiver that you're talking about is this idea that we didn't necessarily secure unanimity, but you should deem unanimity found because there was no instruction. How can we deem unanimity found when the verdict form reflects that the jury was not unanimous? So ordinarily, a deemed element is an element of a cause or a claim that's missing, and the jury answers everything in connection with that claim along the lines of meeting all the elements, and so we would deem it. But how can we deem it here when the jury hasn't answered everything in line with all of the elements required for punitive damages?
I think to respond to that in two parts. First, to clarify, it may not necessarily be something that needs to be deemed, just because the unanimity requirement was waived in the first place. It just wasn't required here when reviewing the charge. I pointed to cases with deemed elements found more as, I think, instructive just to the analysis of how this court has looked to cases in the past with a charge defect or something omitting an error. And second, to what evidence is in the record to support a deemed finding of unanimity on 8. I think the best thing to point to would be the instruction to only get to question 8 if you were unanimous on question 7, as well as the answer
Right.
of...
But you could see that a jury that was all in agreement on everything and the underlying liability questions, which I agree with you, we can gather from question 7 that they were, but they might not agree on the amount of punitive damages because punitive damages are different, and some jurors might say, I don't think they're really, I think the amount that we're awarding is not really the amount necessary to deter this conduct. So it is a different question that the jury's answering in 8.
Yes, it is different, but in looking at the verdict in light of the entire context, the jury did give $75,000 to each plaintiff, which seems to reflect some sort of unanimity there amongst the jury. For these reasons, the judgment of the Eighth Court of Appeals should be affirmed.
Can I ask you, before you sit down, I don't think you've had a chance really to respond to the citation of Zorilla. And that case seems pretty relevant, and I don't think it was in your brief either. Do you want to just tell us why you think that doesn't inform our analysis before you relinquish the podium?
Yes, I don't think that case informs the analysis here because statutory capped the damages are something that can always be applied retroactively. And so you don't need the jury there in order to apply a statutory cap to punitive damages. But in this case, when looking at what the jury said and what the jury found, any discrepancy or alleged conflict that Oscar Renda wants to rely on could have best been cured by the jury themselves, and they failed to raise that in front of the jury. So I think that's the distinction there, is that statutory caps can always be applied after the fact, whereas if there's a alleged issue with jury findings, that needs to be resolved in the moment before the jury is discharged. And that's consistent with this court's recent line of cases.
Any other questions? Thank you, Mr. Gray. Mr. Anderson, you have 5 minutes.
Justices, I feel like the issues are all properly joined. I would like to stress the statutory nature of Chapter 41. I believe that it's the province of the legislature to make those requisites, and Texas voters agree. Punitive damages are strictly controlled. The burden of proof can't be shifted, and there's nothing in Chapter 41 that creates some sort of burden of proof for the defendant on punitive damages. I think that this is already clear, but I would like to point out that the Redwine versus Peckinpah case does, to me, resolve completely the 301, the Rule 301 component of the purported waiver. You asked some very poignant questions on 295, and I've given you my best answers. But if there is something that a remaining question that I can address.
I want to know if you think the statute protects defendants from themselves. For example, if a defendant were to literally agree to an instruction that says, if 10 of you find punitive damages will be awarded, and no objection to that. In fact, an express consent to it. Do you think the statute nonetheless would say, too bad, you didn't get unanimity?
No, I don't think that the statute would protect a defendant in that situation.
So is that our job now is to decide whether or not that's the situation that we're in this case?
I think that Renda's case is strengthened greatly by the fact that in this particular instance, very rare, all the stars align, where the burden of proof, again, at each turn falls on the homeowners. And I think that I think that the overall scheme of Chapter 41, and as well as Justice Alley and Justice Green, certainly in his dissent, joined by 3 in Menchaca, I think that there is a lot of pull to it.
A lot of?
That it has a lot of traction.
It seems that your position hinges on there being a difference between intentional knowing waiver of a right, which I think you just said would allow a verdict that was not compliant with the statute. A difference between intentional knowing waiver and on one hand, and then on the other hand, the kind of waiver we talk about when we just note that there was no objection, there was no argument, and therefore we call the issue waived, even though there may not have been an intentional decision to waive it. You think that's what it comes down to?
I think that's a pretty good analysis, Your Honor. I think that at the end of the day, that chapter 41 it goes beyond just the elements of the charge and an admitted element. I do need to research that some more, and I will do that. But yeah, in a nutshell, I think that Chapter 41 is intended by the legislature and the voters to protect defendants in a different way, in a statutory, in a scheme that is pretty comprehensive as you look at all the various components.
It seems to me that would be answering the question differently, because it sounds to me like what you're saying is the answer to this depends upon the nature of what was being decided by the jury. And then isn't that going to really open up a can of worms with regard to our jurisprudence having to do with the duty to object to charge error, depending upon what the cause is or whatever the issue is that's before the court or before the jury?
I think that the 41003 means what it says, and that is that there is no burden of proof on defendants, and that in order to obtain punitive damages, you very clearly have to have definitive, affirmative, certified answers to all 3 of those issues. And I don't think that the court should guess defendants into that situation.
So that would apply to other issues where there's other statutory directives that's similar to that, right?
Well, it would depend on the purpose and tone of the statute.
Any other questions? Thank you, Mr. Anderson. Case is submitted. That concludes the arguments we have in the cases this morning. Again, court is pleased to be able to hear our argument in cases in El Paso. In just a moment, we'll return to the bench here and give you the opportunity to ask us questions about the court and its operations, and we'll be able to share with you that way for several minutes. But for now, we'll ask the clerk to adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.